Phil Bador, which is, I believe, Ms. Vitale's brother. We have a letter from David Renner, Ms. Vitale's son-in-law. We have a letter from Alan Johnson, who is the son-in-law. We have a letter from Christine, who spoke today. We have a letter from Ann P., who I believe is a childhood friend, as well as a letter from Betty Tucker and Kay Raymond, also childhood friends of Ms. Vitale. So the court is in possession of those letters and has reviewed them. Mr. Simon, before your client has an opportunity to speak, is there anything you wish to say on his behalf?
Yes, Your Honor. There were a number of letters that were attached to our memorandum as the court received and reviewed those as well.
Yeah, I mean, those are all, sure. When you did the Cobb's memorandum, I reviewed all those before. So we do have a letter more recently from Lauren Oshman, MD, from the Michigan Medicine Practice regarding your client's physical health. That would be something that was, I think, post your Cobb's memorandum.
No,
so I reviewed everything.
Yeah, there were a number of letters that all the letters were not repeats, Your Honor. There were fresh letters, and I just want to make sure the court had an opportunity to review them.
I've reviewed everything in the file. Yes.
Thank you.
So
thank you.
Let me pull them out and I'll note them. Go ahead.
Thank you. You don't need to do that, Your Honor. I trust the court. I just want to make sure the court received them. I know the court reviews everything it receives. Your Honor, I have just a few comments to state. First of all, this is a I want to speak on the law, then I want to speak on the facts, and then I'll conclude. On the law, this is a very unusual case in that the offense for which Mr. Young pled guilty, he virtually completed every element of the law's requirements except one. And it actually isn't to remain on scene. Ironically enough, it's that he had one more step of identification to make. Now, he actually did stay on scene, did identify himself, and help was there before he left. Those things are factually true and supported by all discovery. The other thing, that's the law. But Your Honor, the other thing I want to say is that I don't typically respond to victim statements because Lord knows they have suffered a huge loss. There are some factual representations in the letters that you were sent that I am going to respond to, Your Honor, only to the extent if they have influenced the court at all in reaching a decision. My client denies some of these factual representations. They're pretty severe. For example, number one, the rumors that were referenced, people are saying he's the source of them, that he's been bragging about his defense and denying responsibility. This is something that absolutely categorically denied by Mr. Young, is not consistent with his character that I've come to know. It's not consistent with the character in the letters that people wrote on his behalf. And absolutely, he's not been conducting himself in that small community, which everyone acknowledges. Number two, he never, the trips, every time he has made a trip out of the jurisdiction, he's received permission to go. Every single trip was for work purposes because he's been trying to support his family throughout this time and through support himself and through COVID as a business owner, and then not without driving. You see, as a result of this charge, he lost his license for a year as an automatic Secretary of State suspension. And every single thing that he did travel-wise was for work purposes except one. And there was a reference to a social media post. It was singular, not plural. It wasn't boasting. It was to simply say thank you to those who made a trip, a hunting trip, pleasurable for him. That was the one and only thing that he did that wasn't work-related. Next, Your Honor, Mr. Young there was one person who said that they felt that he was trying to avoid liability for carrying a firearm the night of the incident. Mr. Young does have a CPL, Your Honor, but he has never, ever carried a firearm. He has this license, but he doesn't carry it and doesn't have it at the time of this incident. Also, Your Honor, the last factual thing is with respect to the incident itself. Mr. Young struck his head in this incident. He came to consciousness by an OnStar operator that was talking to him. He was responding yes to. There was references to his engine revving. Maybe that's so. He doesn't know. Maybe his foot was on the gas. He doesn't know. He doesn't remember the accident itself, yet alone the aftermath. But he specifically denies trying to throw the car in reverse and escape. He got out of that car. He went up to try to render aid. He identified himself, and this is all confirmed. So that's my respect to the facts. And then now I want to speak to my last comments on elocution. Your Honor, this is a difficult case because, I'll say one other thing. Well, so much has been made of the delay. First, the people took almost a year to charge the case. Then there was COVID. The court struggled. The prosecutor's office struggled on our request for resolution. And maybe Mr. Dawood will confirm, and Mr. Ganatra, if he's still here, we have always proposed a resolution to accept responsibility. Let me repeat that. Mr. Young has authorized me to get to this place that we resolve the case from day one through today. It has never, ever been our intention to try to avoid responsibility, and I hope the people will confirm. Okay, last thing on elocution. Your Honor, it's like I said, a strange case in that the offense is weirdly almost not an offense based on the conduct, but it is true that Mr. Young, who was, the people raised questions on being suspect as to his most recent automobile accident. He was the victim of a driver who I attached the traffic crash report to our memo, who crossed lanes and struck him head on. There was some suggestion that he may have been at fault in his accident. No, and he is rendered very seriously injured as detailed in our memorandum and also by the probation department. We have asked the court in our memorandum not to impose any upfront incarceration. At one time, we'd suggested a delayed sentence to get him right. He has tried to go forward with his life since the incident happened. He did get married. He has a child due in May, his first child, and his work situation and his financial situation is dire, to say the least, given the things we put out there. Probation has recommended 30 days in the Washtenaw County Jail and probation. Your Honor, I ask the following. A, we ask that you not impose any upfront incarceration. And if the court is going to impose incarceration, allow him a report time that is not higher than what probation recommends, but also when he's medically best capable to do so. I know the court has done some investigation on that as well. Thank you, Your Honor.